Here's the second thing, and this goes back to the ranking member's comments about yesterday. To me, yesterday was an awful day in the history of this committee. It set new low after new low after new low. And I'm not going to talk about all of the new lows. I'm going to talk about one in particular. And that is whether anybody noticed the irony that the day before the United States Department of Justice arraigned a former FBI director for allegedly making untruthful statements to this committee, the Attorney General of the United States sat right there and made untruthful statements to this committee.
In a moment that cut through partisan noise, Senator Sheldon Whitehouse delivered a sharp, fact-based rebuke that exposed serious contradictions in testimony from the highest levels of the Justice Department. What followed was not political theater, but a stark warning about truth, accountability, and the rule of law.
And they weren't maybe untruthful statements. This wasn't a question of nuance. She made allegations about the ranking member and me having received political contributions from some, she said, Epstein close confidant. Well, guess what? That's actually checkable. There's a thing called the Federal Election Commission. The Federal Election Commission keeps a website that tracks all of our contributions. An intern at the Department of Justice could have checked to see that the allegation, I'll leave it to myself, that I had received campaign contributions from this individual, that was false. And it's not a maybe answer, it's a yes or no. Did I or didn't I? And there's an unimpeachable record that shows that what she said sitting right there was not true. If we are going to care about untruthful statements made by the Department of Justice and the FBI in this committee, let's not have this be yet another area where there are different rules for one party than for the other party. And just by the way, on that very subject, the other thing that the Attorney General did sitting right there was to strip all cover away from the untruthful statements that had been made to this committee by the current FBI director. You all heard him here. He said that he couldn't tell us about his grand jury testimony in the Mar-a-Lago case, where he first pled the Fifth, then got immunity, and then testified. He couldn't tell us what he testified to, he said, because the Department of Justice had sealed the testimony and because there was a court order barring him from doing that. And he actually identified which judge, the chief judge of the D.C. Federal District Court. Well, guess what? We know that since then, the chief judge of the Federal District Court has said that that was not true. He said specifically nothing prevented Director Patel from discussing his grand jury testimony. And yesterday, the Attorney General had the chance to say, you're right. We did seal the testimony in that matter. The Department of Justice did seal the testimony, and Patel's statement was true. Not about the court order, but at least it was sealed by the Department of Justice. She didn't say that. So now both his testimony that the DOJ had sealed his testimony and his testimony there was a court order barring his testimony are kind of demonstrably false statements to this committee. And then when he came back and we challenged him on those false statements, his second false statement was to say, I'm not going to answer any of those questions because my transcript of the grand jury testimony, I've worked with the DOJ to see that it is publicly released. Well, it either has been publicly released or it hasn't. It's a very simple distinction, yes or no. And we all know that it has not, in fact, been publicly released. And when we asked about that from the Attorney General, again, she left him high and dry and refused to say that anything had been publicly released, that there was any publicly released transcript. So yesterday stands in really stark contrast. I should say the day before yesterday stands in really stark contrast to yesterday. Yesterday, an FBI director was arraigned for making a false statement. The day before that, the Attorney General of the United States made arguably even falser statements. We'll see how the other case turns out. And she left the current FBI director completely exposed on his multiple false statements that his grand jury testimony in the Mar-a-Lago case had been sealed by the department, was under court order not to be released, and had since been publicly released as a transcript. I don't know if this committee is going to take itself seriously enough to treat false statements to this committee as serious matters, irrespective of who made them. But the contrast is really stark. Thank you, Chairman.
This exchange marks one of the most consequential moments of congressional oversight in recent memory. Senator Sheldon Whitehouse, that he methodically outlines what he describes as a troubling pattern of untruthful and misleading statements made to Congress by Attorney General Pam Bondi and FBI Director Kash Patel, statements that directly conflict with verifiable public records and judicial findings. His argument is not rooted in speculation or partisan framing, but in documented facts that anyone could confirm. Whitehouse begins by highlighting the bitter irony of timing. One day after a former FBI director was arraigned for allegedly making false statements to Congress, the sitting Attorney General appeared before the same committee and made claims that were demonstrably untrue. Specifically, Bondi alleged that Whitehouse and the ranking member received campaign contributions from an Epstein-linked individual, an accusation that can be easily checked through the Federal Election Commission's public database. That record shows the allegation to be false. Whitehouse emphasizes that this was not a matter of interpretation or nuance, but a clear yes or no question with an indisputable answer. He then turns to what he describes as an even more serious issue: the Attorney General's failure to correct false testimony previously given by FBI Director Patel. Patel told the committee he could not discuss his grand jury testimony in the Mar-a-Lago case because it was sealed by the Department of Justice and subject to a court order issued by the Chief Judge of the D.C. District Court. However, the Chief Judge later publicly stated that no such court order existed and that nothing prevented Patel from discussing his testimony. Whitehouse notes that Bondi had a clear opportunity to clarify whether the DOJ itself had sealed the testimony, even if no court order existed, but she declined to do so. The situation worsened when Patel later claimed he could not answer follow-up questions because his grand jury transcript had since been publicly released. Whitehouse points out the simplicity of this claim. Either the transcript has been released or it has not. It has not. Once again, the Attorney General refused to confirm any public release, leaving Patel's statements exposed as false or misleading. Whitehouse contrasts this treatment with the aggressive prosecution of a former FBI director for allegedly lying to Congress, raising a fundamental concern about unequal standards of accountability. If false statements are punished only when made by political outsiders or former officials, but ignored when made by those currently in power, the principle that no one is above the law collapses. Beyond individual claims, Whitehouse frames this as a systemic threat. Congressional oversight depends on truthful testimony. When executive officials provide misleading information or refuse to correct it, Congress loses its ability to investigate abuse, enforce the law, and act as a constitutional check on power. He also flags concerns about potential violations of long-standing DOJ policies restricting White House access to sensitive investigative materials, particularly related to Epstein records, which are designed to prevent political interference. At its core, this moment is about democratic survival. White House's message is blunt: if honesty in testimony becomes optional, oversight becomes meaningless, and democracy itself becomes fragile. The erosion of truth inside the Justice Department does not just harm political opponents, it undermines public trust, weakens the rule of law, and leaves citizens vulnerable to corruption and abuse of power. This hearing serves as a reminder that accountability is not partisan, truth is not optional, and the health of democratic institutions depends on enforcing both equally